Okay, it's 10:05, so we will get started. So welcome back to the second day of the AAH Doctoral and Early Career Research Committee's Professional Development event, or welcome if you are just joining us today. My name is Danielle Smith. I'm one of the members of the DCR committee and one of the organisers of the event. We had two really great sessions yesterday with the curatorial roundtable and then the workshop on grants and bursaries. And some of the discussion in there in particular set us up really nicely for this morning's first session, which is on copyright and image permissions in art history. And it's my pleasure to be chairing this current session. So the idea for having a session focused on image permissions specifically as an aspect of professional development in the field was something that came up in discussions that we had not just as a committee when we were planning this event, but really just generally kind of with our friends and colleagues as well. That this was such a crucial bit of what we do that we were all just still a little bit in the dark about, even if we were already in the process of preparing articles or chapters. So the aim of the session is really just to try and demystify some of the elements of the copyright and licensing process for images, and hopefully make those of you who are either already dealing with images for publication or who will be soon just a little more comfortable in forging ahead with this aspect of it. So on that note, I'm very pleased to introduce our speaker for today's session, Victoria Hooper. Victoria is the head of licensing at DACS, which is the Design and Artists Copyright Society. It was founded in 1984, and it's a not-for-profit organization that works to collect and distribute royalties to artists, creators, and their beneficiaries. Victoria has worked at DACS for 19 years, having studied history of art and architecture. She is responsible for client management, driving the business development of DACS's services, and ensuring that those services remain fit for purpose and also competitive. And she is actively involved in discussions with international counterparts to understand how visual rights and negotiations are playing out in different territories. So Victoria will discuss copyright and licensing specifically from the perspectives of the practicalities of licensing copyright artworks. And then after that, we'll have plenty of time for questions and further discussions about the topic. So I'll hand over to Victoria to begin.
Great, thanks, Danielle.
Thanks.
Okay, let me share my screen with you all. Okay, I hope everyone can see that. Not getting any screams, anyone can't. Right, so okay, so thanks ever so much for allowing me to join the professional development sessions that you guys are having. As Danielle says, so I'm the head of licensing at DACS, and hopefully kind of my purpose is that at the end of this presentation, you'll have some practical advice that you can use going forward. And I'm hoping that I can dispel some of the myths that are associated to copyright licensing. So it's a good start. Next slide. There we go. Right. So just a little bit about DACS, and then I shall go through a brief kind of intro into how to find rights holders, the licensing process, some misconceptions, as well as exceptions to copyright and some copyright cases that have recently come about. And then looking at kind of diversity of licensing, so it goes beyond publishing. And then also a hot topic at the moment, a little snippet on AI and the impact of that on visual artists. So as Danielle mentioned briefly, just to introduce DACS and who we are. So we're the Design and Artists Copyright Society. And we were set up by a group of artists and lawyers in the 80s with a focus on protecting and campaigning for intellectual property rights and supporting artists to make sure that they get paid for when their work is used. This year is actually our 40th anniversary, so we're really pleased to be celebrating that, especially in this climate. It hasn't been easy. So we're a not-for-profit organisation. There are no fees for our rights holders to join any of our services. We simply retain a small percentage of any royalties that we collect, which covers our costs. We fulfil our mission by making sure that artists receive royalties by operating different services that support the business side of being an artist and helping artists to monetize their rights. So we give artists a collective voice when it comes to receiving payments for the use of their work. We keep artists informed of their rights and help them to debunk myths and jargon that they can find in their practice. And we also actively campaign and lobby at government level to ensure that artists' rights continue to be protected and they're not eroded by the ever-changing political landscape. So our core services, we operate 4 services for our members. These are payback, copyright licensing, art image, and artist resale right. So for the purposes of today's talk, I'll discuss in detail the copyright licensing side of that, but also briefly touching on art image. So copyright licensing. So basically, I manage a team of 8 people in the licensing department, and they manage requests for use of our members' works. So whether that's in books, magazines, on websites, possibly by a museum, by brands. The use of our members' work is really varied as to how that can be reproduced. So through this service, we take on the management of these requests and provide a bridge between clients, so the end user, and also the artist. And we cover everything from negotiating the terms of how the image will be used, ensuring that an agreement is put in place that protects the artist's rights, but also gives the terms that the end user needs in order to make their project successful. And we look at ensuring that the reproduction of the work is produced at a high standard and guaranteeing that the associated copyright fee is fair and in keeping with the actual use. And this is a really important point because I think there's also some misconceptions that copyright is going to mean pound signs and it's going to be really expensive. So again, I hope to debunk that idea. It's also worth noting that at DAX, we've got an international network of sister societies that we belong to. So that means that as well as representing UK artists, we can also represent international members who are part of that sister society. So providing quite a robust and extensive repertoire of works to clear. In 2023, just to give some stats, we arranged approximately 2,000 licenses for our members and worked with over 600 customers, which resulted in securing 1.6 million for artists and their beneficiaries through licensing. So, how to find the rights holders. So this is one of the aspects that can be extremely challenging when needing to clear copyright and finding actually who does manage the rights and how to go about doing that. So to start with, just to go back to basics, once an original work is created, copyright lasts for the lifetime of an artist plus 70 years after they pass away. So after which point, the artist and their created works are in the public domain and free to use. So if you're before that point, then copyright is going to need to be cleared, and that's where the likes of DAX come into play. So again, how do you know where to go to clear that copyright? So obviously, my recommendation, first port of call will be DAX. Our website has actually just had a complete overhaul, so hopefully you'll find it user-friendly. But there you'll be able to search for over 300,000 artists that we represent worldwide just by typing in the artist, either first name or surname, or even pseudonyms. And hopefully you'll be able to get a successful match. Failing that, another avenue to try is WATCH, and that stands for the writers, artists and their copyright holders. And this is actually a service which is jointly run by the Harry Ransom Centre and the University of Reading Library, and it's a really comprehensive search and something that has organically built over the years. So again, very good source to try there. A basic internet search is always a good place to go, and you might find that actually by doing that, it will lead you to where that artist or even their work in general is held. So if you're able to ascertain that information, that's another good source to try. So contact that collection or the gallery, as they should be able to provide you with details or pass on your information to the rights holder to secure that copyright. BAPLA, that's another organisation, and that stands for the British Association of Picture Libraries and Agencies. So looking at it from the visual side, they represent an array of UK picture libraries and again can be a useful source in locating rights holders. So part of this process, by checking these sort of sources and there's a whole array of other sources. This is by no means exhaustive. It enables you to carry out a due diligence process, and this is really important. So, if you really do feel like you've exhausted every avenue, and you're still coming up at dead ends, but you do wish to include that content in your work, then you can go to the .gov site, and they operate an orphan works license. And those, obviously, as it suggests, are works by which no rights holders have been able to be found. You'll also find there an inventory of orphan works, which over time people have been able to find the rights holders. So you may be lucky and find that the content you're searching for has already been investigated and researched, and the rights holders have been found. But failing that, they manage a scheme by which you can gain a license from them and pay a fee to them. And the fees that they apply are dependent on the number of works that you're wishing to clear. And they start at £20. So it's a fair fee, I believe, in order to get that license and have that confidence in knowing that you have made every effort possible to secure the rights holders. And really, it's about ensuring that you have done your due diligence process to try and ascertain who the rights holders are. But in some instances, they just simply do not want to be found. But yeah, this is a good starting point. So the licensing process. So hopefully, by carrying out trying to find out who the rights holders are, you have managed to establish the rights holder. And then what do you do next? So in order for a license to be put in place, what you need to be able to do is provide information as to how it's then going to be used. So the funded information to include is, what it is that you're doing. So are you producing a book? Are you producing a catalogue? Is it for website use? Is it for an article? All of that information. And then the territory in which that's going to be distributed. So are you looking at worldwide distribution, or is it solely going to be in the UK? Print run, as it says on the tin, how many are you going to be producing? What's the run of the publication that's going to be produced, as well as the format. So obviously in this day and age, it's highly likely that you're doing dual format. So you'll be producing the print as well as a digital version of that. So again, that's really important information to include when you're clearing the rights. Once all of that information has been gathered, then it should be that you're provided a fee for use. And this, by you can then ascertain as to whether that's going to fit with your budget, if it's beyond your budget, and then obviously, if necessary, negotiations can ensue. There's a few tips here that I'd just like to kind of bring to your attention. So it's worth noting that generally speaking, if you're looking to use an artwork for a front cover use, it's highly likely that you're going to have to submit a PDF layout for the use, so that the rights holders can see that and ensure that they're happy for the use. In general, I'd recommend that you allow for 2 weeks to clear the rights. This should be more than enough, but again, it just depends where those rights holders are and how easy they are to contact. Where possible, for a kind of smooth process, I'd recommend avoiding cropping, overprinting, and manipulating the work, as it can cause a bit of a delay to getting permission granted. But generally speaking, from our perspective, if the work is used within a publication and it's shown in its entirety, we are able to clear the copyright within 2 days. So it kind of gives you a bit of a steer as to the time that can take. So a few misconceptions that have definitely come past my desk. And one of those is, whose responsibility is it to clear the copyright? Is it the author? Is it the publisher? So there's nothing set in stone, and it's very much up to the parties involved. We find that sometimes this is put at the author's door, and other times the publisher is very happy to manage the clearance. The main thing to note is that permission is sought and it is obtained. So what we have historically seen is that publishers try to push it onto the authors so that they can benefit from lower fees. Now, this is something that over the years we've really we recognise, but we've also tried to ensure that publishers aren't misusing our pricing structures that we have in place. So bearing that in mind, we actually operate several different tariffs which could apply to yourselves, which I just wanted to highlight as part of this session. So one is the standard publishing tariff, where a print run can vary between 100 to 80,000 print run, and that's our standard publication tariff. So that's when you're kind of talking about maybe your Bloomsbury, maybe your kind of Thames and Hudson, Phaidon, those kind of high profile publications that have got sizable print runs, worldwide distribution. Then we've got a rate for academic publications, and in order for this to apply truly to academic publications, we have set criteria which has to be satisfied in order for a significantly reduced rate to be applied. So the kind of things that are applicable are things like, is it a work of original thought? Is it based on new research? Has it been peer reviewed? Is it written by an established academic rather than an in-house writer? So it's those kind of things, again, that help us to make that distinction between an academic publication and a standard publication. Another rate that is more recent for us in administering is our zero rated tariff. And hopefully what you'll kind of gather from this conversation is that what we do a lot of, and it's part of my remit, is to really speak to our clients and better understand what they're doing, how they're working with copyright works, and what we can do to facilitate that. And a huge part of that is ensuring that the fees that we administer on behalf of our members is not prohibitive. So this is how this particular tariff came back, which was speaking to the academic community and understanding that when you're creating an academic journal, that actually there are no budgets, and it is down to the individual to clear the rights. So again, we've got set criteria that has to be fulfilled in order for a zero rate to be applied. And in this instance, we will simply issue you with a license agreement, which again gives you the terms of use, says what it is that you're doing, giving you permission, but at no cost to yourself. And again, that was something that we had a lot of conversations with our rights holders about, and it was something that they, were very happy to endorse. And more often than not, they wanted their works to be included in these particular writings, rather than their works being carved out because they couldn't be afforded. So this is kind of where we're quite unique in having that balancing act between being the broker for the artist, but also liaising very closely with the clients. A final tariff that you may come across is that for a monographic publication. So a publication where it's solely based on one artist. And in these instances, what we find is that there's a large number of artworks by that one artist being produced. So actually to put a fee on the per work basis would become too much and too expensive. So in these instances, a royalty rate is applied, and that's very common across the industry standard. So we'll look at a percentage based on the sale of the publication and the print run that's being produced. So as you can gather, our fees are based on the commerciality of the project, so hence a coffee table publication is going to command a higher price than that of a lower publication and academic in nature. So a couple more points to note, which are that it really doesn't matter about the size of the reproduction. I know that this isn't necessarily true across the industry, but at DAX, again, in conversation with our artists, what we found was that our artists were saying, actually, if somebody can reproduce my work at full page, I'd much prefer that than it being produced at a thumbnail size. So please don't, charge a greater fee for that. I simply want my work to be included at the best and the highest standard as possible. So the size of the reproduction doesn't come into play. Another point to note is that it also doesn't make a difference whether the work's shown in black and white or colour. Again, falling back to the point that I just raised, which is our members want their works to be shown as, in their best light possible. So that often means in colour. We're frequently asked about kind of, how to, I've got the image file, so have I got permission? Or, okay, you've just given me permission to use the work, can I have the image file? Now, these are two very separate aspects. So the supply of the image file is separate to the copyright clearance. Hence, if you do obtain an image file from an image source like Tate Gallery, for example, it's highly likely that you'll need to gain copyright clearance from the artist or an organisation like DAX for the reproduction of the work, and vice versa. So copyright is separate to the image supply. We do have an image bank ourselves, which is called ArtImage, whereby we can provide the image file and the copyright simultaneously. So that's something to consider. So there are some instances, however, where you don't need to clear copyright at all. And I will just run through a few of those. So these are known as copyright exceptions. And in some instances, copyright approval must be sought from the rights holders. Well, this is in most instances, but there are a few in the UK where permission doesn't need to be sought, as it falls under a legal exception. So I've just included a few here, which are most likely to apply to yourselves. And these are known as fair dealing exceptions. So these are criticism review. And this is as it sounds. So it means that it's possible to reproduce artistic works for the purposes of criticising and reviewing those works. So, for example, if you've written an article about Francis Bacon's Screaming Pope, and you're talking about, the blurring of the purple and the brush strokes, and the artist's use of colour and things like that. Now, that article is going to be far more understood and make more sense if you've got the visual there to support it. And it's things like that whereby this particular exception is to enable the use of works to, further illustrate the text. Another exception is reporting current events. So this exception can apply when the artistic work has been reproduced, whether in print, broadcast, or online, and for the specific purpose of reporting on events of national political importance. It's important to note at this that the event has to be current, so if it deals with a contemporary issue. Also, this exception is quite unique in the sense that it doesn't apply to photographs, so they are not covered as part of this exception. This is for works of art. Research and private study for non-commercial research. So this exception covers research and private study for non-commercial ends only. So under this exception, copies of an artistic work can be made under very limited circumstances. It would not cover a situation where someone intends to publish an image as part of their research, or if their research will lead to an artistic work being distributed beyond that private use. Finally, another exception which you might come across, and that's the educational uses for instruction and examination. So in education establishments, here in the UK, have license agreements with organisations such as the Copyright Licensing Agency and the Educational Recording Agency, which allow teachers to make copies of artistic works in books, journals, and broadcasts. But where an artistic work is not covered by a licence, the educational exception may apply. So the exception applies to both teachers and students within a school or university setting, to enable the teacher to illustrate a point and providing instruction to a student. So, for example, using materials in handouts or slides, then this exception will apply. And similar for examination purposes. So if an artwork is being included in an examination question, then again, the exception will apply and no copyright clearance is required. Now, in order for these exceptions to exist, and the kind of fundamental underpinning of all of these is the point that I note that they are covered as part of fair dealing. Now, the aspect of fair means that first off, the work should be sufficiently credited. So the artist should be recognised as well as the artwork. And it's also an assessment of fair based on several factors. So looking at the amount of the original work used, that the work's not mistreated, so it's shown its entirety, and that there are no commercial benefits derived from the use. If all of these are covered, then the exception will apply. But it's worth noting that these are UK exceptions, so there will be differences to this outside the UK. And you may have also come across the term of fair use, and that's the fair dealing version in the States. So there's a slight kind of difference in fair dealing in the UK versus fair use in the States. Okay, so just an example here, just one thought is quite an interesting one to share with you guys. So this is it's a good illustration of when copyright is still applicable, even if the entire work is not reproduced. So even if you're reproducing part of a work, whether an exact copy of the work or reworking derived from a copyright protected work, we'd always advise that you get in touch with us. We're always happy to give you a steer and to look at things, to give you our general advice and guidance as to whether we think copyright permission needs to be sought. So in this example, which is real life example, you've got the work on the left, which is actually from the Chemical Brothers album, and the work on the right, which is an artwork by our member Herbert Bayer, Things to Come. So we know this isn't an exact copy, but there are similarities, but they're not identical. So does it mean that a substantial part has been reproduced? So the test here is to look at the similarities, so how important they are to the work. So you can see in this instance, you've got the hands in the same place, you've got the eyes on the hands, you've got a blue background in both imagery, and you've got the stars and circles being joined by lines. So for a copyright infringement to be determined, there must be a connection between the infringing work and the original work. So the infringement has to be derived from the original. In that sense, there's a little bit of a myth around that if I change 6 things, then that's sufficient change and it's no longer an infringement. It can be deemed a new piece of work. Unfortunately, that's not watertight because essentially the work is derived from the original. So the important thing about copyright infringement is that it's a question of degree. So each example is looked at on a case-by-case basis. In our view, this was an infringement in this instance, and as such, our member wished for us to kind of look into this and make contact with the record label, who in retrospect have put a license in place to ensure that they continue to use this work legitimately. Another kind of legal case, which I think has been heard a lot about recently in various articles, is that of the case called the THJ versus Sheridans. So we're nearing the end of my presentation, fear not, but I just did want to kind of touch on this. So this case deals with a dispute, a software dispute, in fact, and it discusses copyright protection of graphic interfaces. And the Court of Appeal addressed whether copyrights subsisted in the graphic interface and the graphic displays produced when the software is in use. Specifically, this related to the risk and price charts that were being reproduced. So the judge was asked to consider, in particular, whether these graphics were original under Section 1 of the Copyright Design and Patents Act 1988. So to kind of rewind and go back to the beginning, for an artistic work to be eligible for copyright protection under the UK copyright law, it must be deemed original. So an artistic work was said to be original if it was not a copy and the work was a result of the author's own skill, labour and judgment. So this has sparked a number of people to write on this particular case, and it's opened up the dialogue of institutions and image banks charging for out of copyright content. So while not applicable directly to photographs, the ruling restates that the legal test determining copyright protection of all kinds of visual works can be used. So the test has been applied by English courts since 2009, and in short, it grants protection of those works that are original. So they bear the marks of the author's own intellectual creation. So it's crucial to remember that the debate over copyright and whether a content owner charges for an image, they're separate issues. So those supplying images of out of copyright works may simply be charging for the supply and the service that they're giving, and not necessarily the photographic copyright. So that's an important distinction. So you can bear in mind that, you know, those institutions that are providing out of copyright content have gone to the effort of, you know, color management, captioning, cataloging, etc. So, you know, it could be that they are charging to cover that service that they've done. In the case of the THJ versus Sheridan's, it doesn't change the basic fact of the originality test. It is simply highlighted that the enduring and complex question of what qualifies as original, and, you know, what that's deemed under the law. So at Dax, fortunately, we solely manage within copyright works, hence our connection with the rights holders. But I would always advise caution. Don't assume that there are no fees just because the work is out of copyright and in the public domain. It is something just to be mindful of. Okay, and finally, nice kind of visual slide for you all. I just wanted to leave you some examples of how our members' works have been used over the years. So we've done everything from Miltag, who produce cycling clothing. On this example, you can see Sir Peter Blake's work being used, all the way through to Peggy Angus's work on a range of cushions by Blithfield, and of course, a beautiful selection of front cover uses by a number of publishers. So the use of artworks is growing, and I'm sure you've spotted some artworks in your recent watch on Netflix. And there are various merchandise collaborations in the market at the moment. So we are being constantly delighted by the innovative ways in which our members' works are being used and incorporated into new projects. And we can only anticipate that this is going to grow. Another area that we are keenly keeping an eye on is that of AI, which I think even this morning I heard it being spoken about in the news, and its impact on our members' rights. And as such, we're heavily involved in actually the conversations at government level. And last year we conducted a survey of our members. And just to give you a few stats, just of interest, so 74% of respondents noted that they are concerned about their work being used to train AI models, and 89% of respondents had the feeling that the UK government should put in safeguards and regulations around AI. However, that being said, at the same time, our results also showed that a third of artists are using AI as a tool in their practice or to assist with tasks related to their work, which again is kind of showing the significant impact on AI and what it could mean to artists in today's world. So on this basis and on the survey results, Dax has actually made 5 policy recommendations to the UK government, and lots more can be read about this on our website if you're interested. But just to rattle through those 5 points. So consent, control and compensation being 1, transparency, regulation, international competitiveness, and then finally incentivizing human creativity. So, you know, it's a big, as I said, it's a hot topic at the moment. It's one that we are very much actively involved in and keeping an eye on, so it's of interest to us. So that just leaves me to say thank you. Thank you for taking time to listen. I do hope that you found some of this useful, and you've got aspects that you can take away and consider further. And yeah, I'd be very happy to take any questions that you might have. I just need to stop sharing.
Great. Thank you so much for that, Victoria. We definitely have a few questions already coming through. I will say for me, one of the biggest takeaways from that, which does line up really nicely with some of the advice we heard yesterday about grant applications, is just to really know your project and know exactly what uses you're looking for and where it falls within the different classifications, so that when you are pursuing the licensing or the copyright, you're making sure that it is fit for the purpose that you are looking for. So that was really, really interesting to hear, especially about sort of the current and future plans for Dax and how they're looking to manage things going forward. So I will say, if you have any questions, you can either raise your hand and you can come on the microphone and ask them directly. You can pop them in the chat, or you can message me directly if you prefer. I'm Danielle Smith. I should be at the top of the list. But we already have a few, so I will get started. I will say that rather selfishly, you did answer the burning question I had based on my previous experiences, which was the hierarchy between if DAX or if an artist's estate is managed, but the work you're specifically interested in reproducing is in a public collection. Who do you go to? And the answer is both,
Yeah.
which is great to know. So the first question we have is about open access. What is the approach to open access publications? What kind of tariff would that fall under for DAX? What's the understanding there?
So it really is on a case-by-case basis. So the best thing to do is to provide us with a very brief email as to your project, what it is that you're doing, the content that you're looking to include, so our members' works, if that's applicable, and we can kind of take it from there and give you advice as to whether a copyright license will be required or not. I mean, we're, as I started, we're a not-for-profit organisation. We're not looking to create work for the sake of creating work. So we'll be very, open and honest with you guys as to whether a copyright license is necessary or not.
Okay, great. Amazing. The next question we have is, would you be able to speak a little bit more about the permitted use or exceptions for criticism and review? Is this something that is more applicable to a journal article rather than a book publication? Yeah, a little bit more about the rules around that.
Yeah, so as with anything legal, it's all grey. I mean, life would be nice and simple if it was black and white, wouldn't it? But yeah, I mean, it really doesn't matter so much about kind of like the context of use. I mean, you need to kind of think about the rationale as to why that work's being included. And again, looking at the aspect of fair. So, for example, if you have got a book and you've got a chapter about brushstrokes, but in that chapter, which is 2 paragraphs, you've used 20 examples of brushstrokes. You could make the argument that actually that's no longer fair. Do you need 20 works to illustrate 1 point? So it's that kind of judgment. So as I say, like, it's not black and white, unfortunately. It'd make my life a lot easier if it was. That's why kind of on these instances, it's looking about those aspects on a case-by-case basis to identify whether it is fair, whether it isn't fair. But generally speaking, if you are critiquing the work and the work is fundamental to your writing, then there is a likelihood that the exception will apply.
Okay, great, amazing. Thank you for that. Someone has asked, could you please remind us if you know about the rules regarding scanning a high resolution digital copy of a work from a book? So how old does the book have to be? What's the position if it's a new book but an out of copyright artwork?
So fundamentally, if you're scanning a work, I mean, if it's in copyright, then there is copyright clearance to be taken. Obviously, it's somebody else's copyright, intellectual property right that you're dealing with. So I would say, take some caution with that. And then what was the other aspect? Oh, about whether it's in copyright. So again, I mean, literature has a slightly different copyright, I believe, to artistic works. So again, just being mindful of that. I think you've got the association, ALCS, so Association of Literary Society, I believe it is, something like that. Everyone's got these acronyms. But yeah, they're probably a really good place to look at when it comes to literary rights, and what is in copyright and what is out of copyright. But generally speaking, I'd just say just be cautious. And again, that element of due diligence is really, really important.
Great, amazing. I can see Sunny has her hand up, so I'm going to see if she wants to come off mute and ask a question.
Hi, I just figured it's easier than typing it. Thank you for that. That was really, yeah, I feel like it's been demystified in many ways now. But I do have a question, and it's quite a selfish one. So I work with feminist print and magazines for my research, which at the time I guess copyright wasn't necessarily secured by many of, because it's alternative press as well. So how do I go about seeking permissions to use, for example, cover images or advertisements? Because sometimes they'll reproduce an artwork, for example, on the front cover of the magazine. So Lubaina Hamid's work, but then it'll be designed by a different designer, and the magazine I work on is no longer in publication. So there's many gray areas of how to seek permissions.
Sure.
And many times it's women that weren't, say, artists in that sense.
Mhm.
So sometimes it's just illustrations by women who contributed to the publication. So that's a very, yeah. So what would you recommend, I suppose, with instances like that?
I would say try and kind of explore all those different sources. So,
Mhm,
I know you kind of said that the magazine is no longer in existence, but
mhm,
if you could try and weave your way through, whether it be,
mhm,
it's got bought up by Condé Nast or another large publishing house that
mhm,
may still be producing it, it's a good kind of place to start. The
mhm,
artists themselves who contributed, see
yeah,
if they've got any information, whether it was under a commissioning agreement. Failing
mhm,
all of those, if you really do truly believe that you've exhausted every single avenue,
mhm,
and as I mentioned in my slide, you've gone through that kind of due diligence
mhm,
process, then, and I'm sure you've all kind of come across it in your lives, which is you can include a disclaimer in your publication and how you're producing it, just to simply say, every effort has gone to identify the rights holders involved in this publication. Um, you know, please, contact us should you have any further information. And, then you can look at dealing with things in retrospect. But in order for that really to kind of hold any merit, you have to have truly exhausted the avenues to try and find those rights holders involved.
okay, that's great. Thank you.
No problem.
And I'm guessing you would advocate for keeping a record of all of the different avenues you have exhausted, so that if
$100%.
it does come to
Yeah.
anything, you can show everything
Yeah,
that you tried to do.
definitely. A good starting point for that for a template is the .gov. So looking at the Intellectual Property Office, and again, that Orphan Works, they've got a really clear template that you can include for your due diligence search, where the sources that you've tried, the dates, all those kind of things, as a point of kind of capturing that information, so you've got something to call back on should you need to.
Great. We actually have a question about the orphan works and the orphan work licenses. Do you know if there are any EU equivalents to that process or any EU image databases in general?
Good question. I don't, I'm afraid. As with a lot of things, we do work very closely with our European counterparts. So it wouldn't surprise me if there was a version of that somewhere. What we do find with our kind of dealings with our international societies is that quite a large number of collecting societies like DACS are actually government run. So there is a high likelihood that there'll be some government scheme in operation in those territories, which I'm sure will be able to further sort of help with the rights clearance for various authors and rights holders.
Okay, great. On a very similar note, we've had someone wondering if you might be able to say a little bit more about how copyright does work across countries. So, for example, if you're publishing an image by a work by a US artist with a US copyright holder, but it's in a UK publication, where do you get licensing for that?
So really you should be clearing copyright and where your publication is being produced.
Mhm.
So it's a bit like kind of, driving the car, here in the UK, we drive on the left-hand side. Just because you're going to go over to the States doesn't mean that you take it with you. You have to adhere to their legislations and their laws. So similarly, it doesn't really matter if it's, if the artist is Brazilian, French, whatever. If your publication is being produced in the UK, then you should be adhering to UK law. And, again, whether that's the work in the collection states or from the artists themselves, adhere to UK law, be mindful that those rights holders may have certain terms they wish you to follow. So various stipulations they could wish to put in place. So just being mindful of that, but generally speaking, you should be following UK law. So if an exception applies, then it doesn't matter, for example, the nationality of the artist being included.
Okay, amazing. And that's even if you're looking for a worldwide print run or a worldwide
Yeah.
publication, if the publishing house is in the UK.
Exactly.
Okay, amazing. A couple of questions also around sort of copyright versus out of copyright. So would you be able to expand upon the fees that might come with an artist who is out of copyright but is protected under something else like ARS or ADAGP?
So if the artist is out of copyright, which is obviously kind of 70 years, then here in the UK, if they are still in copyright within another territory, so for example, Henri Matisse, he falls out of copyright here in the UK at the end of this year. So come 2025, you can all start reproducing your Matisse works without having to come to DAX to clear copyright. However, in the States, he will still be in copyright, for example. So in those instances, if you're producing a publication in the UK using Matisse's work, then you're fine. You can reproduce the work free of charge. But you do just need to be a little bit mindful if your publication then gets picked up by an American publishing house for redistribution, then rights clearance are going to have to be applied. But generally speaking, if it's out of copyright here in the UK and you are a publishing house in the UK, then those are the rules that you have to adhere to. Does that answer your question, Danielle?
I think so. If the person, yes, that did answer her question.
Okay, good.
And a kind of a similar related one are there instances where you need copyright granted even if the artist has been dead for over 70 years? So do you not need copyright from that artist's estate if it is still managed?
If the artist is out of copyright, then the artistic copyright does not need to be consulted and cleared. Again, it might depend upon the image supply, so the actual image file that you're obtaining. There may be rights in that. So that kind of element, which is the TJH versus Sheridan's, which has come into conversation quite a bit recently, which is, okay, well, the work is out of copyright. Why am I still having to pay for Leonardo da Vinci's works? I just want to reproduce them. He's out of copyright. What's happening? And it could very well be that the fee that you're being charged for is the service fee by the image bank for providing that physical image file. So it's a business decision as to what people are charging for. But from a copyright perspective, the artistic work is out of copyright.
Okay, amazing. And do you know if anything changes if the work's authorship is disputed? So if it's suspected to be by a particular artist, but it hasn't been officially accepted, I guess. Is there any difference there?
I mean, I guess it's really a case of being kind of practical about it. You can only do what you can do, which again kind of goes back to that disclaimer aspect, which is if you've tried, seeking clearance and you've done the right thing and you've, obtained the copyright that you deem is appropriate, there's only so much you can do. If that then gets challenged further along the lines, then obviously that's kind of out of your control. I mean, we'll see it a lot within members. This is a collaborative work. No, it's not collaborative work. It's solely my work. So we see it from the rights holder's perspective, but not from an end user's perspective.
Okay. And a couple of comments or questions just on this idea of separating the copyright from the image supply. So for example, if you buy an old photograph from Bridgman Images, you still need the copyright on top of your purchase of that image itself, if the artist is within copyright.
Exactly.
Yeah.
Exactly. Yeah.
Okay. I know this is a big thing for people who are working on artists that are out of copyright, but just the cost of the image licensing from the various institutions. And
that is something we're really mindful of, which is why it's really important to kind of be party to these conversations. And we do very much engage with our clients to really understand, which is why we don't do any sort of e-commerce service, because we want to kind of understand the project, because every single project, to be quite honest, is quite different. And there's always some nuances that, it's really important for us to hear about. And how we operate is fundamentally, if our pricing structure isn't working for your project, but you do still want to proceed and you're really, really keen to use that content, what we will do is we'll go back to the rights holders and we'll basically plead on your behalf and say, look, is there any benefit that we can do here? Is there anything we can do providing a further discount? because fundamentally they're not our rights, we're the administrator, so we're not in a position to be able to waive fees or to reduce fees significantly, but the rights holders can. So it remains within their remit that they can challenge our fees. Not always to the benefit of clients, I must admit, but where we can, we will try and be that kind of level head and kind of liaise between the two parties. So do please provide us with as much information as possible, but at the outset, I would make provisions for the image supply as well as the copyright clearance where you can.
Okay. And another related question, what would be the best approach if an author wishes to reproduce an image from, say, an auction house catalog? So the image itself is out of copyright, but does the auction house, who, if we presume they took the photograph, or the current owner need to be contacted for you to use that image?
Again, it kind of boils down to where you're getting the image from. So if you're then contacting the auction house for the image file, then they may be charging you a fee. If you're going to start scanning images from books, you're not going to be getting the quality. It's really not going to be fit for purpose. But from a kind of, and this is something that we do kind of get a lot of, which is, again, more from the other perspective, from the rights holders, which is, I own this Damien Hirst work, therefore I can reproduce this work because I own it. It's like, no, copyright, it's an intangible right, but it resides with the rights holder. So it resides with Damien Hirst, it resides with Picasso administration, unless they have assigned their copyright in formal documentation to another party. So just by owning the work does not mean that you have the copyright in the work to reproduce it or to do anything with it. So that's another aspect to bear in mind.
Okay, so in that instance, if we assume the artist is out of copyright, it's more about the licensing or the reproduction of the image itself, which would reside with the auction house.
Yeah, exactly.
Okay, great. If there are any other questions, we're just almost out of time. Please send them through. Otherwise, I'll just quickly ask, can you tell us anything, if you know about any international developments that we might need to be aware of? Specifically, do you know if any other international agencies are adopting this kind of zero charge tariff that you were talking about?
So this is something which I'm speaking quite on a regular basis to our international counterparts. None of them have applied a zero rated tariff that I'm aware of, but they do have lots of other kind of exceptions similar to what we were saying earlier. Criticism review, private study, which can be applicable. But we're constantly exchanging information as to how to really sort of strive that balance between enabling clients to use the members' works as well as ensuring that the members' works are fairly reproduced. So I don't know of any, in answer to your question, short, but it is something that is constantly being looked at and considered, because to be quite frank, there's quite a lot of footfall from the academic community who want to reproduce works, and actually you're reproducing them generally faithfully for low print runs, and there's a legitimate reasons to wanting to reproduce those, which is why I say in my presentation that the majority of our rights holders are actually really supportive of that. So that's why we created the zero rated tariff, is to reflect that and enable rights holders' works to be used, but also for end users and clients like yourselves to be able to do that.
Amazing. I know a lot of us will be very grateful for that as we forge ahead with journal articles and the like. All right, so we are pretty much out of time. So thank you so much for all of that. It was incredibly helpful, and definitely, just speaking for myself, demystified a lot of the process around copyright licensing and all the different aspects and the different kind of definitions of all of those terms was really helpful as well. We will have a kind of list of resources and top tips that we'll publish on the website when the event is over. So if you want to refer back to any of the information, we'll have that listed for you. And just a reminder that the next session starts at 11:30, which will be the CV and cover letter writing workshop. Feel free to stay on the call. We will put everyone back into the waiting room for the half-hour break, but we'll bring you all back for the start of the next session. And that's pretty much it. Thank you again so much, Victoria, and hopefully that was helpful for everyone.
Great. Thank you so much for inviting me.
Thank you very much.
Thank you. Bye-bye.
We'll see everyone at 11:30.